very good afternoon to all of you from Nidhi Singh, founder and advocate at law, NRI Legal Services. Today's FB live session, as it has been displayed by us, is on adverse possession, law of adverse possession. I will be today talking about this law, but I'll be talking about it in the applicability of it. Not going to go into technicalities because I feel that this law has been much talked about, and I feel from the queries that we keep receiving from all over the world that there are still people who are not very clear about it. So I will try and talk to you as a lawyer who's trying to explain a concept in a very, very common sense terms, and I hope you're with me to understand what this law of adverse possession means. Why such a interest in this law? Actually, last year, this was in August 2019, suddenly Supreme Court passed a judgment on this law of adverse possession, and it created a huge chaos all over the world, that now our lands and properties in India are not secure at all, and we are, and mostly as our people are NRIs, we focus on delivering services to non-resident Indians. So when we were overseas, people were asking us that now our properties in India are not secure. There is this new judgment, and by this judgment we might just lose our possession. We are sitting so far away. What can be done? So a whole lot of interest, a lot of myths, a lot of rumors started floating around. So I would like to give you the background. Then I would like you to make you understand what exactly has Supreme Court recently in the judgment that is so talked about actually held, and what are the pros and cons, and how does it affect each one of you, so that there's a complete understanding. So right from the start, every title holder has an absolute right in a property. We all know it's my property. I have the title deeds. I am the owner of this property, and I have given this property on rent. I have given this property to a caretaker to take care. I have my relatives staying. In some capacity or the other, that property is being used either by myself or by someone else. Now, in all of these events, the property is yours. You have the title on it, and there is no disputing that title at all. In whatever capacity you have somebody, whether you have somebody you have a written contract, you do not have a written contract, but the property remains yours. Now, as it happens, is very common in India, and very, very common amongst the non-resident Indian community, that they had given their properties to people to look after when they left India. Their grandfathers did it, their great-grandfathers did it, their lands, their houses. When they left the country, they were being tilled by somebody else, and it all went on, and a lot of people were very proactive, a lot of people were not, a lot of people lost touch with their properties. So these are the people who actually did not have the physical possession of these properties by virtue of just being away, and a lot of people did face a lot of challenges in getting their properties back. Now, whenever you have a property anywhere in India, whether you live here or you're a non-resident Indian, you have to remember that if it is in somebody's possession, and you have to get that possession back. Now, sometimes if there is a dispute in that you are trying to get a possession back and you're not getting it because that person is not willing to give up the possession, or is not willing, it leads to a legal situation, and that legal situation goes to court. So typically, what do you file? You file a suit for possession. Now, when you file a suit for possession, that a property holder files a suit for possession, there is a provision which was always there, that the defense side, the person who's defending his possession, he has a right to take a plea of law of adverse possession. He can say that I am taking this plea. He files an application that I'm taking this plea. Now, what does it mean, adverse possession? Why and how is this applicable? So this is basically a provision which was given to a person who has been actually possessing this property for a long time, and he, because he was good with that property, he was improving the health of that property for a long period of time, which actually I'll just come in a minute. What does long mean? He actually has a right on that property, and he actually has improved the value of that property or worth of that property. So the law recognized that. The law recognized and wanted to give him the benefit of that. Now, what is the scenario? After all, I am the owner of the property, and a property title holder has an absolute right, and the law is saying that okay, you can take this flea and you can take this property. No, it is not like that. It is not that easy. So there are elements that the law strictly want you to adhere, and if you actually fulfill all of these elements, then you can take this plea successfully. Now, what are these elements? The elements are very clear. That you should be in actual physical possession of that property. The property should be yours physically. You should be stilling it or staying in it, or it should be with you completely. It should also be a very open kind of a possession. It's not something that you're controlling that possession through a third party. No, you're in physical actual possession, and it can be very evidently clear seen that it is an open, notorious. The word is, it should be open and notorious for the world to see that you have physical possession. So the first clause is actual, the sub clause is open and notorious. Second, the element says of adverse possession that your possession should be continuous and it should be uninterrupted by the statutory provision of law under the Limitation Act 1963. Section 65 gives you this right of adverse possession. This is that if you have been continuously and in an uninterrupted way been holding onto a property for 12 years or more, you can take this plea against the owner who is trying to get the property back. Now, once these two elements are there and clear that yes, 12 years, yes, actual possession, the most important and the very vital is your possession has to be adverse or hostile. What does it mean? That it should be against the owner's wishes. It should be against the interests of the owner. It should not be a permissive possession. It should be adverse. The title says law of adverse possession. Now, if you fulfill these three, and you have been you're completely fine with it, and all these elements are attributed to you, you can file this application and you can actually take on the title. This title is a negative title. Its title is against the proper owner, and this, though an absolute title, is a title that can rest in you on this basis. Now, squatters' rights and such rights are very, very common all over. That if somebody has been completely looking after a property or holding a property and has these kind of possession rights, the law gives them this benefit. Now, what happened here was that there were these, since this was only a defense plea, what Supreme Court did last year was that in Ravinder Kaur Garewal versus Manjeet Kaur and others, now this is the talked about judgment, the Supreme Court just took it a step further. Supreme Court held that if you fulfill all these three elements of adverse possession, you can, instead of using it as a shield, meaning instead of using it as a defense plea, you can now use it as a sword, which means you can go on and file a declaratory suit for title on the basis of adverse possession. Very revolutionary, very definitely, there was a lot of confusion, but at the same time, nothing really changed. What the Supreme Court is trying to say, that if you as a defendant can hold your ground or your possession right, and all of those three attributes are very well attributed to you, or they imply to you, then you take it a step further. Rather than waiting for the person to take his possession back, you can actually go to the court and get this title. It's a negative title, but an absolute one. It's a title that you can pass on to generations. It is not a very, it is an illegal kind of a possession, in the sense that the possession is negative in nature, but the title is very much an absolute title. And for this, a lot of people thought that yes, they have been sitting in these properties for a long time, and there was, they could now, almost through this judgment, actually go ahead and file cases and take on the properties. And they did that. Now, there's a very important component that's completely missing. What we are not understanding is that nothing is changed. Let me tell you, and to all of you, that if I were to statistically tell you that generally in the courts, it was a very weak defense. Mostly when it was used as a shield, as a defense plea under the Limitation Act, it was a very, very weak defense. Nobody virtually nobody could actually fill on these attributes. People just didn't have anything, so they would just file this application, and 9.9 times out of 10 this plea was rejected. So nobody would even give it importance, because they wouldn't be able to find all these three elements present in a one person. Now the same elements have been transferred into, nothing has changed, has been transferred into filing of a declaratory suit, and the elements remain the same. Now also it is a way that I don't think it is strong enough. It has the same, that 0.01% people actually who are filing would be able to get this kind of relief, injunctive relief against the real owner. There is no disputing, and there can never be any dispute, that your property as a title holder will remain yours. People cannot take this plea and deprive you. This huge myth and rumors that are floating around, please understand that technically nothing has changed. Law of adverse possession is just the same. It is just that the person can also proactively file a declaratory suit rather than just being on the defense side. But mostly, a lot of cases, the lawyers are filing left, right and center in courts, taking up this plea. They have to understand that to prove that this is an adverse possession is actually virtually impossible. You see, when we say the possession has to be adverse, who all have gone out of the race? People are saying, oh, I have a caretaker, I don't have a verbal agreement. Will he be able to take? He's been living on my property for more than 12 years. No. If your relative is in the property, would he be able to take on your property? No. Because he's placed there by your permission, not by anybody else. Now, a lot of people say, oh, my grandfather made somebody, stay on the property, and now it's been so many years, 30 years, we've not returned back. What is going to happen to our land? No, he cannot take this plea. Why? Because he came into possession through the permission of your grandfather, who was the then owner. How will he fulfill the attribute or the element of adverse or hostile possession? So he cannot. Your family, your blood relatives, even if they don't ask you and get into the property and just take over your property, they can never take this plea of adverse possession. They could not as a defense. Now they cannot as being the plaintiffs filing a suit. Your cousin is staying in the property. No. You have a tenant who has stopped paying rent. For so many years he has not paid rent. Can he now claim adverse possession? Not at all. the tenants cannot. Once a tenant, always a tenant. You see, if this would be so simple and this would be so easily achievable, then the whole purpose of law or holding a title deed or a valid title deed would be completely lost. Then anybody can deprive you of your title, and it would absolutely create a complete confusion in the property laws in India. So basically nothing has changed, as I have said. Always remember, no matter if the statutory period has been more than 12 years, you are in the actual possession. But if it's a permissive, that is, it is with the permission of the owner that you are holding that possession, no matter what, you cannot claim adverse possession. So all of those people, so what is the scenario in which somebody can successfully claim it? The only thing that I can feel is that there is a trespasser in your property, and either you have not bothered, or you know that there is a trespasser but you have not done anything about it for 12 years or more. That means a trespasser does not have permissive possession, he is hostile to the owner, and he is in possession. And if this period continues again for 12 years and you have not done anything to evict him out of the property, you've not served him any notice, you've not done any legal case against him, he then can claim his right as a plea that he can take for title on basis of adverse possession. Otherwise, I really don't think. Somebody said, well, these people, they went into the property, I gave them the possession on the basis of agreement to sell, and now they're claiming adverse possession. The possession was given by you on the basis of any document, even if they don't have a title deed. That does not mean they will be claiming adverse possession. They cannot. So virtually claiming a title, a good valid title, is virtually impossible. So please do not start filing just because you have a property which you have for 12 years or more, thinking that this judgment is now going to give you a right and deprive the title holder of his title, or you as a defendant can take up this plea. No, you have to make sure all of these elements are completely met and are completely applicable to your claim as claiming the title. Now this is very, very important, and I feel that what you should very quickly, I will tell you that what are the added things so that people can't file cases against you. A lot of people are owners, and they are being a lot of cases against them on their properties are being filed, and especially a lot of our NRI clients and friends and audience are complaining of this. So quickly I'll tell you that while this law I am sure I've clarified, but you need to have written permissions. You need to make sure the utilities, like standard, I've been saying this for years, standard things, utilities should be in your name, you should be very clear with your permission, your statuses should be clear, you should not have a person on a property for long periods of time, definitely not for 12 years, and you should have very clear proactive management of your properties. You should try and be very participative, no matter where you are living, participating of your in your property, so that you do not have trespassers coming into your property and taking hold of your property. That can be a very, very cumbersome and a problematic situation. So keep up all the important points that we keep talking about, and do take action on them to manage your properties yourself. So on this note, I'm also going to announce that in different cities in UK we are having open days. we will be advertising or disseminating this information on the internet, where our teams would be present. So a lot of people who have any kind of issue with their Indian properties and they want guidance, our teams would be there in Leeds, in Bradford. Also we have offices in London, in Birmingham, in Leicester, where teams are always there. You can always go and take guidance from them. The other thing I would like to say is that please subscribe to this. It will give me the encouragement that I will take out more time, and I would try and disseminate more information to clarify doubts that people have. Please like our channel, clarify. We would be doing a series of such live FBs where important laws which are confusing to general public are discussed. And if on this also, I'm sorry I haven't taken up any questions personally, but you can always send these questions. If there's any further clarifications on adverse possession, or you have a specific query, just feel free to send it to us. Like and subscribe our channel for sure. This will give us the much needed encouragement, and my team who works very hard to disseminate this information to you. Also let us know if you're interested in the open days. The more encouragement we get from you and the more response we get from you motivates us to keep bringing you the very latest and the very simple legal information from NRI Legal Services. I, Nidhi Singh, on behalf of my team, would always be there to help you with any query. Yeah, what is it? Oh, okay, yeah. And I always want to add, in this COVID days, please take all the precautions. It is the precautions that will save you and your own immunity. Please don't take a chance. Be very careful, be very safe, be very healthy, and let's all respect environment and nature. Thank you so very much. Bye-bye from Nidhi Singh and my team at NRI Legal Services.